Excellent. So while we're getting seated, I'd like to introduce our two individuals, Greg Dorrington and Karina Wilmot, and a little bit about each of them. For Greg, he is a partner at Crowley Fleck and here in Helena, and a member of the National Resources and Environmental Litigation Practice Group. In addition to the government affairs work, he maintains an active immigration law practice where he assists businesses and individuals with their immigration needs. Prior to joining Crowley Fleck, Greg practiced in a firm in Anchorage, Alaska, representing clients on a broad range of affairs, including environmental permitting, counseling, litigation, and also immigration. Karina Wilmot is to Craig's right, and Ms. Wilmot is an associate attorney with Crowley Fleck, also here in Helena. Her practices includes employment law, immigration / I-9 compliance, and estate planning. Karina works with employers and businesses on day-to-day issues in the workplace and litigation avoidance strategies. Prior to her time at Crowley Fleck, she worked in human resources as a recruiter for new hires with an organization that had over 5,000 employees. So with that, it's a pleasure to welcome you both, and thank you.
Thank you, David. It's a pleasure to be here. Thank you to the Chamber for inviting us. We're excited to be here. Special thanks to Webb and Bridger for giving us the mid-afternoon siesta slot here. So we'll try and keep it as lively as we can and keep you awake. So I think the other presenters have really done a fantastic job outlining a lot of the legal developments in Montana and the areas and opportunities for reform in the state. We're going to take just a little bit different approach here, and we're going to focus on federal developments, what's going on at the federal level that may impact our Montana business community and our employers. And we're going to do that in the context generally of immigration law and some recent decisions of the National Labor Relations Board. So just going to scroll through here quick to get us caught up to speed. This is our disclaimer. None of this is legal advice. Don't rely on it, but go ahead and listen to us anyway. Let's read it. Here's our beautiful smiley faces. These are the topics we're going to hit. I kind of started out wanting to give sort of an immigration law 101 because I'm not sure it's kind of an unfamiliar topic to a lot of people. You hear about it in the news all the time, but do you really understand it? Do you know what happens on a day-to-day basis in the world of immigration law, visa processing, petitions, and things like that? I'm going to try and go through this rather quickly so we can get to the developments, but if you have questions, feel free to ask them at the end or even in the middle if something isn't making sense, because I want to make sure you understand this. Immigration law, it's a federally dominated area of the law, and that's because of a little document called the U.S. Constitution. I bet you've heard of it. The Naturalization Clause calls for the establishment of one uniform rule of immigration. And that power is vested in Congress. And Congress is the one that enacted the Immigration and Nationality Act, which creates our entire immigration system. It's, of course, implemented through regulation, which have been promulgated by predominantly the Department of Homeland Security, but also the Department of Labor to the extent it involves employment-related issues. And then that is further trickled down into agency memoranda, policy documents, agency guidance that actually dictates kind of the day-to-day actions of our agencies and implementation of the immigration system. There are a host of agencies that are involved here. It's not just DHS. You've got, of course, DHS and then the daughter agencies coming underneath of it, USCIS, Customs and Border Patrol, ICE, but you also have the U.S. Department of Labor. And then even the state and local job service agencies to the extent any degree of recruitment is involved for employment-based immigration visas. They get thrown in the mix as well. And then, of course, the U.S. Department of State. And rather than going through each one of those, I'm just going to go through sort of an example very briefly as to what process an employment-based immigration visa petition would go through and all the different agencies that touches along the way. And so say you've got Bridger back here, and he runs a business called Bridger's Bridges, and they build bridges. Yeah, it's just coming off the top of my head. And he wants to hire a structural engineer, we'll say. And he's recruited for one in the U.S. and around Helena, can't find anyone that's qualified, able, and willing to work for him. So he's got to tap into the foreign labor pool. And in order to do that, the first step is to file what would be called a labor certification application to the U.S. Department of Labor. And that would, through that process, Bridges would attest that they're going to pay this foreign worker the prevailing wage for that particular job and in that geographical region. He would attest that he has gone through and undertaken a recruitment effort, and there are no U.S. workers that are qualified, ready, willing, and able to work for him. And assuming they go through those processes and it all checks out, Department of Labor will stamp it, say, okay, you're approved. The next step then is to take that approval and then actually file a petition to USCIS, the United States Citizenship and Immigration Services. They're the ones that evaluate whether the foreign worker is eligible for a particular immigration benefit or a category. And so in this case, it would be an employment-based classification. It could be an H-1B if you're talking about the non-immigrant context, or it could be a green card type arrangement, which is it'd be probably an EB-2 or an EB-3. So once USCIS says, okay, you're eligible, the next thing that would have to happen is that foreign worker would have to go to the U.S. embassy or consulate in their home country and actually apply for the visa. So USCIS doesn't issue visas. They talk about eligibility and deal with the petition work. U.S. Department of State, which maintains our diplomatic missions abroad, they're the ones that will take visa applications and adjudicate whether or not that individual is admissible to the U.S. in terms of a particular visa category. And if they are, boom, they get their visa. And that's basically a movie ticket. It gives you the opportunity to appear at a port of entry to the U.S., present yourself in front of a Customs and Border Protection officer and say, can I come in? And just like a movie ticket, you got to get past that movie ticket taker, before you can go see whatever movie you want to see. And if you're acting drunk or belligerent, they can kick you out and say, no, you've got your ticket, you paid for it, but it doesn't mean you can come in. Same thing can happen at the border with the CBP. They can kick you out, they can ask you questions, and if your questions don't align with the visa category and your passport, they can say, nope, sorry, you're on the next plane back home. But assuming you do come in, or the foreign worker is able to come in, they get a stamp in their passport, say it's an H-1B visa. They'll write in there how long that status is good for. Usually it's 3 years for an H-1B. And then they can stay for that period of time before they have to either leave the country, get an extension, or change their status. And during that period of time, you've got to make sure you maintain and don't violate that status, or ICE could come after you. So that's just sort of a rundown of a typical process. There's a lot of touches, there's a lot of process involved. That's one of the things that can oftentimes turn employers off, is just the amount of work involved to get foreign labor here. But in a lot of cases, if there are no U.S. workers available, there's really no choice, and they're willing to go through that effort to get the people they need to do the job that they need them to do. So immigration, you hear about in the news all the time, California and Texas and some of these bigger states, higher population areas. But, Montana has foreign-born people too. We're not just up here in the hinterlands. We do have a number of folks here that were born elsewhere. And in fact, over 2% of our population are foreign-born residents. More than a third of those have at least a college degree or higher, which is more than on par with our native population. 1,500 are self-employed, pretty decent income generation, creates jobs for over 9,500 people. So there is an economic engine there for the state. They pay taxes, over $154 million in federal, state, and local taxes. Spending power of over $474 million. So it's a big deal. So let's just kind of get into some of the developments now and the challenges that we're seeing in terms of sort of this change of administration and policy shifts going on at the federal level and what those mean to particular employers in the business community in Montana. Generally, what we're seeing at a very high level, and we'll get into the weeds here in a minute in this executive order, but what we're not seeing is a major monumental shift in statute or in regulation or a comprehensive immigration reform. We're not seeing it yet. This may happen, it may not. What we're seeing more of is these incremental changes at the administrative or executive level in terms of policy shifts, how those administrative laws are being administered. So we're seeing frontline officers getting different guidance documents about how they are to adjudicate petitions. We're seeing narrowing of regulatory interpretations. We're seeing increasing scrutiny of petitions, additional documentation requirements. So it's getting harder to comply or to go through the petition process, but the actual rules of the game are not necessarily changing in terms of the words of the statute or the words of the regulation. And a lot of this is stemming from the Buy American, Hire American executive order, which President Trump issued shortly after his inauguration. And basically, what the auspices of this are is to protect the American worker, to protect the American economy by, and you can see Section 2, the directive is to rigorously enforce and administer the laws governing entry into the United States of workers from abroad. Translation, it's going to be harder for you to get into the country to work. The EO also has some directives to the Departments of Homeland Security, Labor, State, and also the AG. The directive is to propose new rules and issue new guidance to supersede or revise previous rules and guidance, if appropriate, to, again, protect the interests of United States workers. The EO also calls out specifically the H-1B program for revision. So this is seen, kind of the trickle-down effect of the EO is seen in a recent change in USCIS's mission statement. Totally fine for federal agencies to adjust their mission statements. That's within their prerogative. This one caused a little bit of concern in the community. The old statement talked about USCIS's role as, America generally as a nation of immigrants. USCIS's role is to provide information and grant citizen and immigration benefits. A little more open arms policy, maybe. The new version retracts a little bit from that, takes out this nation of immigrants, and it puts in that the focus here is to protect Americans, secure the homeland, and honor our values. So you're seeing, just representative in this change in the mission statement, a pretty big shift in how the agencies are viewing and administering our immigration laws. So the interesting thing about the EO, it doesn't change the law. It doesn't do any sweeping immigration, reforms, so to speak. I mean, all of these immigration programs, these are all specific visa programs that Montana employers use and can continue using. These were all here during the Obama administration. They're all here under the Trump administration. Nothing's changed. It's just maybe a little bit harder, or you maybe have a little bit higher of a burden to obtain those visas under these particular programs. So our system is governed by statutes and regulations, and it's going to take a whole lot more than just an executive order in order to change that. So let's talk about just a few of the changes in policies so you can kind of get a flavor for what's going on at the executive level. The first one has to do with the deference given to prior determinations of the administrative agency or the adjudication. So if we came in and we got an H-1B visa for an individual, they were successful in that process. Traditionally, the prior policy was if you went back, that same worker with the same employer went back to seek an extension of that status, that officer who received the extension request had to defer to the prior determination that they were eligible for an H-1B visa. So it would almost go through rubber stamped in a way. The new policy is no deference to prior determinations. Even if nothing material has changed and they just need to go ahead and get an extension, they're going to review that request anew. It's going to be treated as the burden is on the petitioner at all times, no deference given to prior determinations, and there's no constraint on requests for additional evidence if USCIS determines that they need that to decide whether that individual is eligible for that particular immigration benefit. So just an example of additional burden. H-1B developments, I'm going to run through these pretty quickly. The H-1B program, if you're not familiar with it, allows U.S. Employers to recruit and hire foreign workers to work in what are called specialty occupations. Generally requires attainment of a 4-year degree. And think of geoscientists, physicians, even lawyers can fall under that category. But there's been some criticism that employers are focusing on bringing H-1B workers in as cheap labor to replace professional workers that are U.S. citizens. And that's where the fraud and abuse issues come in. There's going to be, under the new administration, more fraud and abuse site visits. So that means USCIS is going to go to these employers. They're going to actually physically inspect them, make sure that the workers doing the work they said they're going to do, they're getting paid for the amount they said they're going to get paid for, and they're working in the area they're supposed to work in. So just additional enforcement and oversight from USCIS is what we're seeing. Additional documentation requirements for third-party work sites. So that's like, you usually see this in IT companies. Bring in a bunch of H-1B IT workers, and then they contract those individuals out to specific companies to do the IT services. Just more documentation needed in order to make that actually happen. So more onerous process. We're seeing an observed trend of more RFEs. That's something called a request for evidence that occurs during the petition process. USCIS can request additional information. So again, increasing the cost of that entire process. DOL and DOJ have also added a couple of statements in terms of what they're going to do to rigorously enforce their laws as well, which we're not going to get into too much because they're just sort of broad statements. Before transitioning over to Karina here, this is a really interesting issue, the H-2B issue. We see a potential workforce shortage issue coming up here. The H-2B program, for those who aren't aware of it, it's a program that allows U.S. employers to hire foreign labor to fill temporary jobs, so seasonal jobs or peak need jobs. Think of Montana's tourism economy. Think of places like Big Sky and West Yellowstone in the summer. Those are the individuals who, or the economies that bring in these foreign workers, hospitality industry. This is why your server in West Yellowstone is from Poland maybe, and the wait staff or the cooks are from Portugal or somewhere else. These are all H-2B workers, and it's a non-agricultural setting. H-2A is for the ag folks. But we've got sort of this interesting confluence of 3 different things that are going on right now, which are generating a potential workforce shortage here in Montana. The first is there's a cap, a limited number of H-2B visas available a year, 66,000 total. Those are split into 2 separate seasons. So there's a winter season and a summer season, 33,000 allocated to each. In prior years, there used to be something called the returning worker program. So an H-2B worker leaves the country, comes back to the same employer, doing the same job. They wouldn't be counted against that H-2B cap. So they were exempt from the cap. That's gone. That is now sunset. So any H-2B worker coming in is automatically counted against that cap. 33,000 ain't a lot for the entire country. So there's a hard cap. There's unprecedented nationwide demand currently for H-2B visas. Let me get the number here. So what happens is, under the H-2B visa program, you can apply. You have to go through a DOL process, and you can do that 120 days in advance of your date of need. So the summer season starts April 1, so you can apply January 1 for your H-2B workers. And on January 1, first day that it was open, over 4,000 petitions were filed for 81,600 H-2B worker positions. That's more than 2.5 times than the amount that are available under the cap. That was the first day. I mean, by February, you're up to over 100,000 worker positions. So there's just not enough H-2B visas available for the number of workers that are in demand. And then finally, low unemployment in Montana. I mean, Montana's got a pretty low unemployment rate, it's hovering right around 4.1%, tracks the national average, but that's even lower in places with high tourism economy needs like Gallatin County. They're around 3%, so there's just not that many workers. And the U.S. Chamber did a study that the demand for H-2B workers goes up as the labor market tightens. So as unemployment goes down, it makes sense, right? There's fewer American workers, there's a greater need for tapping into that foreign labor pool. So all three of these things coming together is really a concerning topic, I think, for the Montana tourism economy, for our hospitality industry. If these companies can't get workers, they can't open, they can't operate. And if you don't have companies operating and catering to the tourism, or to the tourists who are coming in, tourists aren't going to come. And that could have some pretty significant trickle-down effects. So watch this closely. There's a chance that under the March 23rd spending bill, Congress has to continue funding our government. They have to have that passed by March 23rd. They may try and slip some H-2B cap relief in there. That's the word on the street anyway. I don't know if it'll actually happen, but keep an eye on it. I'm not going to go over these two in any depth at all, but other developments, there's just narrowing interpretations once again under the TN visa program. That's for Canadians and Mexicans under the North American Free Trade Act, or agreement, excuse me. Just limiting the types of people that can fall under an economist as a category of entrance. So just another example there. And then under the adjustment of status process, that's where if you're a foreign worker in America and you want to adjust status to a green card, normally if you had a pretty good, strong application, there wasn't any need for an interview. Now the new policy is interviews for everyone, no matter what. So just an example of increasing scrutiny, more vetting going on in the process. So that's where we are here. I'm going to sit down and shut up and let Karina take over from here for a little bit.
Thank you. So that was a nice overview of how the policies are shifting in the immigration world, and one of the bigger shifts that we've been seeing is is on immigration enforcement. And so there's been a big change in how they're enforcing the immigration laws, and it's been kind of a nationwide thing, and it's also affecting Montana. So one of the things that they changed in the last year was from the first 6 months of 2017, there was a 43% increase of arrests from the Immigration and Customs Enforcement. And what their goal in doing this is to deter illegal entry. So if they're thinking, if there's no jobs, then people aren't going to try to come here illegally. And one of the obvious places that that's been happening is in California. They passed some legislation last year, they called themselves a sanctuary state, and they've limited who local law enforcement can, when there's requests from the federal ICE, the local law enforcement cannot detain or arrest individuals unless there's they're on a list of crimes that they've committed. So there's kind of a policy, I guess, dispute in terms of, are we going to enforce these, enforce illegal entries or not? And of course, California uses a lot of these undocumented workers, and they want to support them. And this, since then, that was in October 2017, was a lot of the changes in California. And now, just recently in February this year, 2018, the ICE has gone in and done a lot of raids. So they've gone in, they've arrested a lot of undocumented workers. They've had a lot of requests for information from employers. They've done multi-day raids where they go in 5 days, and they just in LA, they served 122 notices of inspections to businesses. So they're really trying to enforce this policy shift and trying to get businesses to take it seriously. And I don't see that necessarily being as strong in Montana, but it's starting to move this direction. And one of the changes that they ordered was the agents from starting in October 2017, they've been ordered to ramp up investigations by 400%. And that's a big policy shift. And even though we feel like, okay, everything happens in California, of course they have a lot of issues there, it's also starting to happen in Montana. And Montana, we're located in the Salt Lake area of reposability. So that's included with Utah, Idaho, and Nevada. And since last year, 2017, their arrest rates have gone up by 11%, and deportations have more than doubled just in 1 year. So there's definitely a big change in the enforcement within our area. And one thing that's happened here within the state is, since 2005, the Department of Labor and Industry, they released the quarterly unemployment wage insurance reports to ICE. And on these reports, they have employee names, social security numbers, wage information, earnings, and other information. And what ICE is doing is they're taking these reports and they're comparing names to social security numbers. If there's not a match between the name and the social security numbers, there's a presumption that it's an undocumented employee. They're not necessarily giving people deference and saying, well, maybe there was a typo in the social security number, or maybe someone got married and there was a name change. There's kind of presumption that there's some illegal action going on. And so after they cross-referencing these reports, what they're doing is they're sending subpoenas to the employers here in Montana to get more information on these employees. And in February 2018, so one of these, they cross-referenced reports, they asked for subpoena records from the Department of Labor and Industry. And a gentleman by the name of Jordan Deardahl Roberts, he protested. He was a legal secretary here with the Montana Department of Labor. He was morally opposed to providing the information that was requested on a subpoena. He had nothing to do with any of these employees except just making photocopies and submitting them, and he did not want to do it. So this was his Twitter post where he quit his position. He refused to do that. I actually noticed that he had posted a GoFundMe site for other people that were in moral opposition as well, and he raised over $80,000 in something like 2 weeks. So he had a lot of support, and it made the news. Obviously, it hit CNN and a lot of other news outlets. So if you didn't see it, it's interesting to look up and fun to follow. The DLI, of course, still compiled the information and provided it. And I think that maybe some of the trickle-down effect from California, where they're kind of protesting this policy shift, and then the enforcement agents are coming in and saying, no, we're going to serve more notices of inspection. We want that information. It's maybe not the best idea to ignore a subpoena, right? So it's good that the state followed through and gave the information that was requested, but it's something you have to be aware of, is that maybe an employee won't want to do it. So as an employer, you need to make sure that those requests are being enforced. And we're not sure in terms of the requests that are coming out, which employers they're picking on. We don't know if there's profiling, we don't know if they're getting tips, information, or if it's only based on things like the wage unemployment reports. So I guess the moral of the story here is that ICE is active in Montana, and employers in the state need to be mindful of their I-9 compliance efforts. And so that would be the most important thing that employers in Montana can do to kind of stay under the radar, right? The last thing you want is to have a 5-day raid across the state of Montana. And one thing that you can do as an employer, and we're seeing the trickle down here, so there's not, as Greg said, there's not law changes, there's just policy changes, but it's affecting local businesses here in Montana, is to make sure that you're employing individuals that are authorized to work in the U.S. And how do you do that? Well, there's the Immigration and Control and Reform Act that requires every employer, regardless of size, to fill out an I-9 form for new employees. I don't know if you all remember that, the first day on the job, give me your passport or give me your driver's license and social security card. If you didn't, that's a problem. Maybe you should make sure you get that done. Every employer needs to fill that out, and within 3 days of hiring a new employee. And the instructions on the form have been pretty stable over the years, the way you fill it out, the information that's on there, but they have new forms that come out. They just recently had another new form. So anytime you're hiring a new employee, just go online to make sure you're pulling the most recent form. There's always been some changes on there to make sure. And the issue that we're seeing with in the immigration side is that employers, a lot of the non-U.S. citizens that are applying for employment, when they get their ticket to come into the U.S., they're also tagged with a status, their employment status, and they typically come with an expiration date, unless they have a permanent resident card or green card. The employment authorizations that they're getting have a deadline on them, an expiration date, so to speak. And a lot of employers that we run into is they do the I-9 form on the first day, they stick it in their file, and they don't look at it again. Even if there is an employment expiration date on there where they're authorized to work. And so one thing we're recommending is to make sure that you calendar that expiration date on a couple of different employees' calendars. In case somebody's not there any longer, it'll pop up on someone's calendar. Remind them you need to check to make sure that those employees that have employment authorizations that do expire, that they have renewed or reapplied for that, for an extension, or they have a different kind of status that you need to make sure you have that documented. Another thing it's been around for a while, but since 2007, they've required federal contractors and vendors to use what's called E-Verify. That's an online service. It's free to use, and you get instant verification of an employee's work authorization. So if you go into it's online. You just log into it, create an employer ID. And they check records. So when you're on that first day, after an employee accepts a job, you can't do this before they accept the job. After they offer the job and accept it, then it compares the records with the Department of Homeland Security to make sure that the employees are eligible to work, and the Social Security Administration to make sure that Social Security number matches that employee name. And E-Verify is great. Even though it's only required for federal contractors and vendors, any employer can use it for free. And so we're recommending to employers that we work with to go ahead and use the system. And we've actually heard rumblings of people finding out that their employees may not be eligible to work. And from a side perspective, if you do have an employee that is confused about their employment status, they're not sure, there's also an online system called Self-Check, and you can do this on your own. You can go log in on your own individual account, and you can check your employment status to make sure that you're in compliance. So, and if anyone's concerned about having too much information out there, there's also a third system where you can actually put a hold on your own personal employment authorization so that no one can access it unless you take that hold off, kind of like a credit hold or something. You can do that as well. So, so some of the extra challenges that we see in Montana on top of that is that we're pretty remote, and we've seen a lot of employers, they're either from another state and they're hiring one employee in Montana, and when you're filling out this I-9 form, you have to actually see those employment authorization documents in person. ICE has not endorsed using Skype or FaceTime or any online way to verify these documents. You actually have to see them in person. And so in Montana, what do you do if the employer is not here, but they're hiring an employee that already lives here that's going to be working here? You either have to fly them somewhere to verify their employment or find someone in Montana to do it. You can use any licensed attorney, and a notary is okay in Montana. Other states have different rules, so beware. Like California, there's special rules for notaries to be able to fill out the I-9 form. But Montana's pretty relaxed about that, which is nice. You can still have someone be authorized on your behalf to fill out that I-9 form on behalf of the employer. The second big challenge that we have is the Montana Wrongful Discharge from Employment Act. We are the only state in the U.S. that does not have at-will employment. If this is news to you, then you might want to read more about it. Since 1987, we've had this, we call it the WDEA, and after an employee's probationary period, you cannot fire an employee unless you have a legitimate business reason or cause to fire that employee. And we've actually had several calls this year of people that have non-US workers, their employment authorization has expired, and they say, well, what do I do? I'm in Montana, we don't have at-will employment. It's still good cause to fire somebody if they're not authorized to work in the US. And we actually have a specific state statute that states that an employer may not knowingly employ an alien who is not lawfully authorized to accept employment. So there's a double backup there. The reason I put this on here is because we get so many questions about the WDEA and what is a legitimate business reason to fire somebody or not hire them if they show up without the proper documentation. You don't have to hire them. They're not authorized to work in the US. You don't have to be as concerned about that, but I just wanted to highlight as one of the challenges that we have here. And then I'm going to turn it back to Greg to talk about the more exciting part, the opportunities we have in Montana.
Thanks, Karina. Yeah, we didn't want to be all Debbie Downer in our presentation. We wanted to look for potentially some opportunities here utilizing the immigration system in a productive way for Montana. So infrastructure geeks, listen up for just a minute. This is a potential opportunity with the federal infrastructure plan. Maybe you've heard of it, proposed by President Trump. The idea is to turn $200 billion in federal funds leveraged against state, local, and private money into a $1 trillion investment in infrastructure. That sounds real good. Where it gets interesting is, okay, if we don't have the state and local funds, where are we going to get some funds to leverage those federal dollars against? Our legislature has not been very keen on bonding lately, and so maybe where can we turn up some money? The Infrastructure Coalition did a great job getting that gas tax increase in place, and that is helpful in terms of developing infrastructure, but maybe we ought to get a little more creative still and look for potentially some foreign investment that can come in and boost our infrastructure dollars. That's where the EB-5 and Immigrant Investor Program comes into play as a potential opportunity here. It is a program under which foreign investors can contribute up to, it depends on kind of the circumstances, anywhere between $500 and $1 million in foreign investment. If they can show that that's going to create 10 jobs within 2 years, boom, you get a green card, which is a good deal for them. It's also a good deal for the investment being made and the job growth potential that goes along with it. The idea would be to have that money be invested in infrastructure. And there is precedent for this. I don't know if you know of the 520 bridge going over Lake Washington in Seattle. That was partially funded by EB-5 dollars. Over $40 million worth. $400 million worth in EB-5 funds are being used and raised to contribute to reconstruction of the Pennsylvania Turnpike. So there are opportunities. This is being used. It's not perfect. There are glitches and there are difficulties that you have to work out, but it's an opportunity. So just wanted to raise that. I know our time is coming up. Bridger's flashing colored cards at us. I'm not sure exactly what they mean, but the immigration reform in Congress, I didn't want to pass up, kind of the elephant in the room, what's going on in Congress, what's going on with DACA. It's a big question mark. There has been a lot of discussion, a lot of talk in the media and out of our members of Congress, but really nothing has actually happened, and it's unlikely that anything's going to happen anytime soon. President Trump obviously released the White House's 4 pillars for immigration reform. I'll just run through those quickly. If you watch the State of the Union, he touched on them, gave his own flavor to them, but it's basically enhanced border security. That means build a border wall, put more CBP officers down there, more ICE officers to detain and remove undocumented or other immigrants. Restrict chain migration. It's kind of a pejorative reference to family-based immigration. The Trump plan would have that limited to really basically just petitioning for spouses and children, whereas it's much broader than that currently under the existing system. Eliminate the visa lottery program. That's the diversity visa lottery program. 50,000 visas are currently allocated to go to nations of low immigration rates in the U.S. And the whole idea there is to diversify our immigration population. And what President Trump's plan would do is take those 50,000 visas and just reallocate them elsewhere. Part of his merit-based system, a focus on skills-based immigration versus family-based or other type immigration. So, and then the last is DACA, the path to give them a path to citizenship for those dreamers. And President Trump attempted to put the pressure and the screws to Congress to actually do something on that front when he announced in September of last year that he was going to stop doing DACA renewals on March 5th. All of a sudden, there was a hard deadline for Congress to work with and to figure something out. By that date, it led to a government shutdown. Ultimately, Congress didn't do anything. There were a number of bills, 2 bipartisan bills came up, failed to get 60 votes, and then the Trump bill, with all 4 of these pillars involved, got the least votes of all. Anyway, the March 5th deadline has now come and passed. There's not really any major deadline at this point. There are 2 federal court decisions which have enjoined the government from stopping the DACA program. So those decisions are going to wind through the federal court system and eventually go to the Supreme Court. The government asked the Supreme Court to get involved now and deal with it sooner rather than later. The Supreme Court said, nah, we're not going to do that. Let's just let it run its course. And so the pressure is really off of Congress now. And it's unlikely we're going to see any significant immigration reform anytime really soon, to be honest. So the best chance is this omnibus spending bill that's coming up towards the middle end of this month. We may see just little tweaks here and there, but nothing major. And it sounds like the Democratic Party isn't interested in holding the government hostage and leveraging that spending package to push any sort of DACA-related legislation. So that's unlikely to happen. But that's kind of where we are in terms of the current outlook, what's coming down the pike. It's sort of a wait-and-see deal. I know we're running super low, but how much time do we have, Bridger?
Just a few minutes.
Okay.
We'll go a little bit into the break too, like
All right.
5 minutes or so.
Okay. That sounds good, yeah. I don't think there's a ton to cover. Right
No,
now.
I can give a brief overview. This is kind of a big shift from immigration, but I just wanted to highlight some federal changes that are impacting our local employers. And one is, this one is the National Labor Relations Act. This is the federal law that gives Section 7 rights to employees. They have the right to discuss and complain about work conditions, wages, unionize. They can complain about safety issues. It gives them collective bargaining rights. So the NLRA, it's called the NLRA. The NLRA is run by a board. The board is composed of 5 members appointed by the president. Well, guess what? There's a policy shift. Every time there's a new president, there's a policy shift. And what we've seen is, starting in 2004, I'll go back. I'll just skip through some of these. Starting in 2004, there was a policy shift then where they're saying that the mere maintenance of a work rule that could effectively chill an employee's rights to complain about wages or complain about a safety issue, it's in violation of the National Labor Relations Act. Now we're finding the shift turning back the other way. And and so the policy, when you're looking at, the reason this is important is that we deal with a lot of employers that are doing employee manuals. Just having a policy that says you can't complain about your wages, or if you do a Facebook posting complaining about your employer, then you'll be disciplined for insubordination. That was a violation. Now they changed the standard for looking at those rules rather than just saying, if it could be a violation, it is. Now it's changed to, they're looking at the impact of the policy and whether or not they have legitimate justification. So there was a big case by Boeing Company where they prohibited cameras at the work site. Under the old standard, that would be a violation of the National Labor Relations Act. And under the new standard, now they're looking at it in context. Well, they have national security concerns at Boeing, right? They're not just an airline. They're Department of Homeland Security issues. And so they had a good justification for having that rule, and really it didn't impact employees. What do they need to be videotaping at the work site that's going to impact their employment? And so there's been a big shift, and I guess the most important thing I wanted to bring up for this is that we kind of anticipate the shift continuing to happen. Every time there's a new executive, there's going to be a new appointments at the National Labor Relations Board. They're going to interpret these policies in a different way. And so we're just recommending a little caution. We still have employers that their policies are older than 2004, so they're not even caught up to the Obama era, and now they're shifting back. So we're just recommending that employers use a little more caution when they have policies for confidentiality, complaining about their work conditions, having disrespect towards their employers or disrespecting the company or any of those kinds of policy rules. And making sure that when they have these kind of policies that they have a disclaimer in there, not a general boilerplate disclaimer saying if it's against federal law, this policy is null and void. What we want them to look at is to say that, if we have a confidentiality policy, that it's not meant to interfere with those National Labor Relations Act rules, right? It's not meant to interfere with someone's right to complain about wages or right to collective bargaining. That's kind of my big picture overview, but that's something that we keep seeing policy shifts on, and we just expect that to continue to happen. And so this might not be an area where you want to go ahead and change your whole handbook. You might want to construct it in a way that would be effective across the changes, so you don't have to keep updating those policies. So, do we have any questions, yes, for immigration or otherwise?
I have time for one question, if anybody has one. Oh, Kevin?
This may be for Greg.
Yeah, that's fine.
The question that I have is, with the shift on immigration policies that you're seeing right now, are you seeing increased delays in the processing of like the H-1Bs?
Well, not so much in the H-1Bs yet, just because it's the filing season doesn't start until April 1, so we haven't really seen anything there yet. But yeah, we are seeing delays. There's USCIS has a whole listing of their processing times, and they are not necessarily getting better all the time. I haven't seen personally in the cases I've worked on any tremendous decrease or increase in the processing time. Things have been clicking along okay so far, but that's not to say others have had the same experience.